All right, everybody, it's about 1 or 2 minutes past the hour. I think it's probably about time we got started. My name is Ryan Govan. I'm a lawyer here at the ShipSource Oil Pollution Fund. Welcome to our webinar. Compensation 101 is what we're calling it. And I want to emphasize that with that title in mind, we're covering the sheer basics of what the fund does. You notice I probably just said the fund. I'm going to be referring to our organization, which has a very long and cumbersome name, as the fund today. Or the SOPF. Wonderful. So as I said, I'm a lawyer here at the fund. I'll explain a little bit more about what I do later on. One thing I should point out before I get started is that we really want to encourage audience participation. We notice that we've got a ton of you signed in from coast to coast and potentially some people from abroad as well. We encourage you to participate in the several polls that we're going to put to you. There's an opportunity for you to ask questions as we go, and I've got our communications and outreach officer here in the room with me. She's going to flag down a couple of questions for me. So if you notice my head or my eyes dart to the left like that, it probably means a big question has come up on our board over there. I'm not losing my my attention in the audience here. So let's get underway. What are we going to do today? First, I want to explain to you what the ShipSource Oil Pollution Fund is and what we do. Second, how can you access compensation from the ShipSource Oil Pollution Fund? Third, how does our claims process work? Once you get a claim in here, what exactly happens with it? And what's the process that the administrator follows before either making an offer or disallowing your claim? Now, we've been around in our current form for just over 30 years. We had our 30th anniversary celebration back in April of 2019. These are a selection of annual reports that the administrator has issued through the years. So you're welcome to check out our website and you can click through these reports, all of them available in PDF form. They include statistics on the amount of money that we have paid to claimants. They include all kinds of announcements about pressing events in the fund's history as well. Here are some key figures on the ShipSource Oil Pollution Fund. The balance as of today is approximately $411 million. Now, this sounds like a lot of money, and of course it is. What do we do with this money? Well, first of all, obviously, our core mandate is to compensate those affected by ShipSource oil pollution. We'll talk a little bit more about that, obviously, in detail. What else do? We pay Canada's contributions to the international oil pollution funds. These are directed at tanker spills around the world, but this is a very important part of our function as well. And finally, a third item is, well, we conduct all kinds of outreach missions. We notice that the knowledge of the ShipSource Oil Pollution Fund is actually quite limited, and we would like to spread that knowledge as much as we can, because the more Canadians who know about what we do means that more people can seek and recover compensation when they suffer damages. Now, as of December 2018, amendments passed by the federal government mean that compensation for claimants per incident is now unlimited. We used to be limited to about 175 million per incident, and that limit has now been expanded. In 30 years, we have paid over 400 claims and counting. I think that number is probably in the 410, 420 range now. Our largest ever claim our largest ever payout rather, was $4.5 million to two separate claimants when the chalk determination at Tug sank in the St. Lawrence. Now, historically though, most of our claims are under $50,000. This puts things into a much more relatable perspective, probably. Now, we get a lot of questions about, well, okay, your largest ever claim was $4.5 million. Well, is there a minimum amount that can be claimed from the ShipSource Oil Pollution Fund? The answer is no. The smallest ever payout and claim in our history was $217.86. I believe this was the owner of a vessel which had been contaminated by oil from a larger spill. Here are our two administrators. On the left, we've got Marc Gauthier, our deputy administrator, and Anne Lagarde on the right, our administrator, who was appointed in 2016. They each serve a 5-year term, and they're independent. Why are they independent of the government? Well, first of all, they serve a quasi-judicial function. This means that they operate sort of like a tribunal. They make very important decisions, and often those decisions affect the government. So we're arm's length from the government. Our largest claimant, as we'll talk about later on, is a government agency. Now, before I move on to part 2 of the webinar, I want to open the floor to questions. If anybody has some preliminary questions or concerns, absolutely feel free to put them to us. And I should point out as well, I don't want to distract you too much, but in your panel, you should have an option for handouts. You'll notice that our 2 new claims manual documents are there for you. So you're absolutely welcome to review those after the webinar and submit any questions you may have. So I'll give you about 20 or 30 seconds here to type out a question, should you have any. And I'll take a sip of water. Okay, we've had a question from somebody, our first question of the day. Can we share the documents that are in your handouts panel? Absolutely, they're public, they're absolutely meant for public dissemination. They're on our website as well. So by all means, if you know anybody who may be interested, share them. And in fact, there'll be 2 more documents coming in a couple of months, most likely. We've got another question. How is your office funded? Okay. This is from Scott Galloway. Thank you so much, Scott. Back in the 1970s, and you'll note that this is before the SOPF existed, there was another fund that drew its balance effectively from a levy on oil shipments in and out of Canada. The levy was stopped in 1976, and we've essentially grown our balance based on interest and recovery from owners of polluting ships. We'll talk a little bit more about that later. Okay, I think it's probably safe to move along to our next slide. How can you access compensation? This is part 2 of our webinar today. Now, let's take a moment to think about what the organization is called. When people ask me, what is it exactly you do? There can be a lot of confusion around that. I start with the name of my organization, of course, the Ship Source Oil Pollution Fund. Well, what does that tell us? Ship source oil pollution. So the oil pollution has to come from a ship, okay? And there's a fund or a pile of money sitting there. We've talked about that already. It tells a little bit of the story about what we do. It opens up a number of questions, however. So compensation from the fund is available when a ship spills or threatens to spill oil, okay? We've got now threatens to spill oil. That's new information, interesting. And you might have the question as well, what is oil? What exactly qualifies? Further to that, you might ask, what exactly is a ship? These are all very valid questions, and we'll talk about the answers to them in a moment. And finally, into Canadian waters. Well, again, this seems clear enough at first glance, but what exactly are Canadian waters? We'll talk about this in some more detail. First off, ship doesn't just mean large vessels and tankers. You'll notice that this is a very large vessel here. This is a tanker in 1990. Well, what else do we cover? Not just big stuff, but also all kinds of smaller boat are covered too. Now, legally speaking, the word ship is used in our legislation, the Marine Liability Act. But ship actually applies to a much broader class of vessels. We'll talk exactly about the precise definition in a moment. Now, what you're seeing here is in 2016, this former fishing vessel, which was converted into a pleasure craft, sunk in Nanaimo, BC. And there was a 2-tiered response. In fact, 2 claimants came to the Ship Source Oil Pollution Fund and received compensation. It includes fishing vessels. Now, fishing vessels can be, as you know, very small or even very large. And pleasure craft. So right down to what you're seeing here are the remains of a sailboat that actually exploded on the East Coast. And there was a small spill as a result. You can see that white stuff around the outside of the boat. That is sorbent boom or absorbent boom. It's there effectively to absorb the oil pollution from the vessel. Now, even though sailboats carry a very, very small amount of oil, usually, maybe just a small outboard motor, any damage caused by a spill from a vessel like that would be compensable from the fund. Even this thing. Now, what is this thing? I'm told it's a fishing vessel on the Great Lakes, and I'm told it's not even that uncommon. I come from the West Coast, and I spent a bit of time on the East Coast as well, and I've never seen anything like this, but I assure you it is a boat, and a spill from this thing would be compensable from the Ship Source Oil Pollution Fund. Now, let's stop for a moment to think about what else might be covered by the Ship Source Oil Pollution Fund. What other kinds of ship are there? Well, we occasionally see claims from tugs and from barges. Now, the definition of a ship in the Marine Liability Act covers effectively anything that navigates on water. What does it mean to navigate? More or less just to move. And what exactly do we require? An engine on the vessel, for instance? No. As I said, a barge would be covered even if it doesn't move under its own propulsion. If there is oil on it for any reason, whether it's cargo or if it's there to operate machinery on the barge, it's covered. Now, we're going to do our first poll here, and our question is being pushed to you, I'm told. The question is as follows: what type of vessels do you have in your community or in your portfolio if you're a government agency or any other kind of agency that operates that way? We're just curious about what kind of vessels we would be likely to see claims from you or from your organization. So go ahead and punch in your response. I see we're getting responses, which is fantastic. It works. Right. You guys are quick. I'll give you another, let's say 15 seconds. So far, we have a surprisingly even breakdown with tugs and barges in the lead. This is fantastic. Okay, we're seeing fewer and fewer responses now, so I'm not sure if everybody can see the results, but it looks as if we have 83% tankers and other cargo vessels. We've got 91% tugs and barges, 81% passenger vessels, which would include cruise ships, ferries, various other kinds of passenger vessels. 89% small vessels, and 62% abandoned, derelict, or wrecked vessels. Now, we put this one on here because, in fact, the Ship Source Oil Pollution Fund is increasingly seeing more and more claims involving these kinds of vessels. Well, any kind of vessel can go this route, but we see more often than not ex-fishing vessels that have been either successfully or unsuccessfully converted into pleasure craft or liveaboards. It's an increasing a genre, shall we say, of the Ship Source Oil Pollution Fund. Ah, very interesting. Are float planes included? From Kenneth Templeton. Okay. That's a very, very interesting point. I would have to get back to you on that. I would think that during the navigational element on water they would be, but I'm not quite prepared to come out with legal advice on that one, Kenneth. Thank you so much for that question, though. Duly noted, and we will post a response online after the presentation, after we think about it a little bit more. Certainly, to the best of my knowledge, we have never seen a claim from a float plane before, but we're not going to bar the possibility of that happening. Okay, so we're going to move on. I want to make the point that an oil spill is not actually required. We touched on this earlier as well, but what you're seeing here is a vessel called the Clipper Adventure. It was a cruise ship up in the Arctic that grounded, and it didn't spill any oil, luckily, and nobody was hurt as well, if I'm not mistaken. But what happened was very interesting. There was a need to take measures to avoid an oil spill. And those measures, to the extent that they're reasonable, are compensable from the Ship Source Oil Pollution Fund. Essentially, all that's required to generate potential liability or responsibility to the fund is a marine casualty that creates some degree of risk of an oil spill. Now, for the Canadian Coast Guard, for example, to respond, it's not even necessary that there be what at law is called a grave and imminent threat of a spill. It's sufficient that there is just a risk, a reasonable, credible risk that the vessel will spill. Now, that's only for the Canadian Coast Guard, but it's a very interesting point because it means that that agency can be very proactive in its response. Now, who else can be proactive? It's interesting. The administrator, in fact, can be proactive in a legal sense. When there has been an incident, she has the power to step in and arrest a vessel or to obtain security from a vessel owner's insurer to effectively guard the fund and Canadians against the effects of an oil spill, financial effects, that is. And it's interesting that I mentioned financial effects. Rather, I should be clear that the Ship Source Oil Pollution Fund strictly does compensation and recovery. We are not responsible for the spill itself. Government agencies, especially the Coast Guard, would be responsible on that front. And if ever anything does happen at sea, by all means report it to us, but don't report it to us first. First, go to the relevant government agency, almost always the Canadian Coast Guard, or if it's on a smaller scale, perhaps a marina or harbor. Now, what's this here? Mystery spills are also compensable. What is a mystery spill? You'll notice in this photograph, which was actually on the cover of our most recent annual report, you'll notice that there's no ship in this photograph. Perhaps the ship has sailed, to put it one way. What exactly do you do if you notice oil in the water and there's no ship around, or there are so many ships around that you can't attribute the oil to any one of those vessels? Well, no matter what, so long as the bulk of the evidence shows that the spill is ship source, the administrator would be responsible to pay out compensation. Now, what exactly can you do to make sure that you will be compensated for a response to a mystery spill? Well, collect as much evidence as you possibly can. If it's a heavily trafficked area, certainly we want to know this. Take photos. If there are vessels in the area but you can't tell which one spilled, absolutely record as much as you can. If it's safe to do so, even consider taking a sample. If it becomes clear that the kind of oil that was spilled could only have come from a ship, or most likely came from a ship, the fund will be responsible to compensate you. Now, all that said, you are not responsible as a claimant to prove to the administrator that the spill was ship source. But if the administrator finds on the evidence that the spill was not ship source, she is not able to compensate you at all. So it's certainly in your interest as a claimant to identify the ship, or at least to show that it was most likely that a ship caused the spill. Okay, it looks like we've got another question here, so let's take a look at this. In fact, it looks like we may even have a number of, okay, we've got natural resource damage, very interesting, we're going to talk about that later on. What's the trigger for accessing the fund for derelict vessels? Can a local marina clean up a derelict vessel and then access the fund? So this becomes a very, very complex question, believe it or not. Of course, the Canadian Coast Guard, and to an extent Transport Canada as well, have an official mandate to deal with vessels like this. And there's also a complex element as well if whether the vessel actually poses a pollution threat. So certainly you would want to take a close look at the vessel, but you'd want to go first to the Canadian Coast Guard and see to what degree they are ready to engage in a response. And let's not forget as well that the owners of these vessels are responsible and liable to the extent that their vessels cause a pollution threat or cause pollution damage at all. So certainly start with the Canadian Coast Guard and go from there. You may as well want to reach out to us in those circumstances as well. We're not able to respond, but we may be able to guide you to a degree. Let's move on. What is oil? We asked this question a little bit earlier. Now, what does it include? It includes gas, gasoline that is, or petrol. It includes heavier crude oil, which might be referred to as persistent oil. Often this is carried on oil tankers, but it may also be used in some form, bunker oil it's called, to fuel large vessels such as cargo ships. And diesel, lubricant oils in an engine, waste oils as well, and that would include anything that's mixed with water, let's say in a ship's ballast or bilge. Now, something I wanted to touch on here, we have a poll, in fact, coming up. So when I talk about mineral or hydrocarbon oils, what exactly do you think the ship source oil pollution could do, if anything, rather the fund, what do you think the fund could do, if anything, in the event of a vegetable oil-based spill from a ship? We're pushing a response to you. We've got yes and no as your options. We'll give you a few seconds to weigh in. We got a lot of responses coming in, so I'll give you some more time. Okay, another 5 seconds or so, folks. Okay, we've got a pretty consistent breakdown, so I think it's safe for me to move on here. We've got 66% saying yes and 34% saying no. Now, let's remember we're talking about mineral or hydrocarbons here, mineral oil or hydrocarbons here. So in fact, vegetable oil, unfortunately, would not be covered by the Ship Source Oil Pollution Fund. It's not to say that the ship owner would not be responsible or liable under Canadian law, but you would not be able to come to us, unfortunately. So thank you very much for your responses there. The bulk of you are correct, which is good to see. Now you know for certain. Now, Canadian waters, what does this mean exactly? We've got a horizon line that's just disappearing in the fog there, which is symbolic. Not a lot of people know exactly what Canadian waters are or how far out they go. Well, we've got a thing called the exclusive economic zone, and the administrator's responsibility or liability extends to the outside of that, 200 nautical miles from the coast, roughly speaking. Now, realistically, most of our claims happen or most of the incidents that generate claims to the SOPF happen very close to the shore. So it's quite rare that we see anything that far out. And not just the ocean, not just coastal waters, but also inland waters, which includes lakes, rivers, and canals. Now, there's a concept I want to introduce to you called the polluter pays principle, and this is sort of an idea that Canada and various other nations abroad have adopted, both under domestic legislation and under international conventions. What exactly does this mean? Well, it means that the owner of a ship, or the charterer of a ship, or in some cases of a very, very large ship, the insurer of that vessel, is strictly liable for oil pollution damage and the threat thereof from that vessel. Now, what does strict liability mean? Effectively, it means that all you need to do in court is show that the vessel was a ship and that it caused an oil spill or created a risk of an oil spill. And to the extent that you can show those things, you've engaged the liability of the ship owner or the other responsible parties we've talked about, being charterers or potentially insurers of large vessels. Now, if you take it to court, though, if you take this issue to court, you run into all kinds of difficulties. It can be a very long process. It can be a very expensive process. And it can, to some degree, be an uncertain process. So the SOPF exists as a fund of first resort. What does this mean? You can come directly to the administrator with the claim. You do not have to go straight to the ship owner. You do not have to go straight to the federal court. You can come right to us with a well-documented claim, which we will assess and probably pay out to some degree. Now, of course, you have an option. You can go to court if you like, and if you do that, the administrator automatically becomes a party to the action. You're obligated to serve the administrator with your statement of claim, with your originating documents, but essentially the administrator steps in and would be responsible if, let's say, the ship owner wasn't liable at all by virtue of a defense. Well, what are those defenses to liability? War or some other kind of exceptional natural disaster, I should say. Sabotage caused by a third party with intent to do harm. Negligent or wrongful maintenance of navigational aids by a government authority or other responsible figure. So these are quite limited defenses, but if those defenses are made out, the administrator can step in and compensate a claimant. Yep, I understand we have another question here. How likely are you or your do you pay out if the polluter does not, or his liability, sorry, the text is small, or his liability is exceeded? Yes, I was just getting to that. In fact, and a ship owner can limit his or its, I should say, because it could be a corporation, liability, depending on the size of the vessel under Canadian law. If this happens, the Ship Source Oil Pollution Fund is responsible for any excess. And as you know now, the responsibility or liability of the SOPF is unlimited. So if there is a shortfall on that side, the administrator steps in and compensates. Other situations, well, let's say the ship owner is bankrupt or a dissolved corporation. The SOPF would step in. And finally, the administrator has the ability to settle. Now, it's very unusual for the administrator to do this unless full documentation is before her and she sees it as an expedient way to end the proceedings in the court, save everybody a little bit of money, This is not done very often, though, because frankly, these issues don't go to court that often. Usually claimants come directly to the administrator. Now, let's move on. Who can claim? Well, in short, anybody in Canada, which includes the Canadian Coast Guard. Ports, harbors, marinas, we've already had a question from one of those, I suspect. Fishing and tourism industries, okay. What can they claim for? We'll talk about this a little bit later on, but this is very interesting. All levels of government, okay. Provincial governments may be mandated to respond on some level. To that extent, they are also eligible claimants. And also small local governments, small or large local governments, as it were. We've had two substantial claims in recent years from those. Corporations, Indigenous communities for fisheries issues or property damage or economic loss. Individuals, let's say a coastal landowner or perhaps the owner of a vessel that's been contaminated by oil spilled from another vessel. Now, I'm told we have another question. Can a certified response organization seek compensation for response costs? We talked about the first resort and last resort models of the fund. In short, a response organization cannot claim directly to the administrator. An RO, or a response organization, is obligated first to go to court against the owner of the vessel, in which case the administrator would become a party. And we had a question from we have another question before I get to that as well. Indigenous nation governments, yes, absolutely. That would be included both in the Indigenous communities and the local government categories for sure. Okay. So we had a question from the BC Ministry of the Environment and Climate Change on whether a responsible ship owner can claim to the fund. And this is in fact even more limited than the response organization question. Effectively, a ship owner is the liable party. So the ship owner has no opportunity to claim directly against the administrator. Under certain very, very limited circumstances, particularly if a defense can be made out, the ship owner may be able to claim in court against the administrator, who would be liable to the extent that the ship owner is not. So if the ship owner takes measures to clean up a spill caused by that vessel, in the case of sabotage, for example, this may be a place where the administrator would step in to compensate the ship owner for measures. But again, that would have to be proven in court. So very, very limited circumstances for that. Canadian Coast Guard is our largest claimant. Yeah. Oh, I'm sorry, I'm told we have a poll. I'm so sorry, let's see. How likely are you or your organization, we've just talked about who can claim against the ship owner, source owner oil pollution fund. How likely are you or your organization to submit a claim to the SOPF for ship source oil pollution? Here we are. I'll give you another few seconds to respond here, folks. And I'm noticing for the first time, because the print is very small, 63% have responded. I'll give you a few more seconds to respond. Okay, interesting. So we'll move on from here, but it looks like we have roughly a 50-50 split. 20% very likely to claim, 22% likely to claim, and 57% unlikely to claim, which is good news for you folks. But thank you very much for tuning in. Okay. Canadian Coast Guard, as you know, is our largest claimant. Why is this? Well, two reasons. First, we'll consider that awareness of the SOPF is not universal in Canada. It's something that we're still working on with outreach opportunities like this. So the second point, though, is that the CCG, or the Canadian Coast Guard, is effectively mandated to respond when a vessel spills oil. So if there's an oil spill or a threatened one, Coast Guard will be there. And they are, just as anybody else in Canada, able to claim directly to the administrator. So in 2018-2019, we saw 23 of 25 claims come from the Canadian Coast Guard. And generally, as a dollar figure, we're looking at about 80 to 90% per year claimed against the fund comes from the Coast Guard. Now, the more we get the word out about our organization, I suspect the more we will see non-Coast Guard claimants, and that's a very good thing. All right, What do we compensate? We'll give you this quick sketch to begin with. Preventive measures, cleanup costs, those two could be lumped together. We've got reinstatement of the environment, and I believe we had a question on that earlier. We'll talk about it in a little bit more detail. Property damage, but oil pollution damage can also extend to economic loss, fisheries losses, tourism losses, and subsistence living losses, which can also be characterized as economic loss. So, and I believe we have another. Do you do National Resource Damage Assessment, or NRDA? Interesting. Do you do, I assume do here means compensate, Natural Resource Damage Assessment, or NRDA? I'm going to say most likely yes. I can't speak exactly to, I'm not familiar with that acronym, but we'll talk about something that I think may align with what you're asking in a few moments. So stay tuned. Compensable damages overview. Let's go into a little bit more detail about what we compensate here at the SOPF. What are preventive measures exactly? We do admittedly have a little bit of confusion on this because it's an unfortunate word. What do I mean by that? Well, do we fund preparedness for oil spills before a spill or a threat of a spill happens? No. If you're stockpiling sorbent boom, for example, unfortunately, you'll have to do that on your own dime. But as soon as something happens and you're obligated to use that boom, then it's compensable from the fund to the extent that you use it. So what are preventive measures? Let's go into a little bit more detail here. They're measures taken to prevent, to repair, to remedy, or to minimize oil pollution damage from a ship or boat. What does this mean exactly? Well, let's say we have a spill. If you deploy boom to contain that spill, absolutely compensable. It can also include monitoring, though. Let's say you have a vessel sink in a marina and you feel the obligation to defend your property because you may have oil spreading from the spill. If you're effectively deploying resources to watch what's happening and perhaps report to the Coast Guard what's happening, to the extent that those monitoring measures generate a cost, that would be claimable as against the SOPF. Now, usually preventive measures are taken by the Coast Guard, but of course we've mentioned that it might also be marinas, harbors, ports, maybe even coastal landowners or vessel owners taking measures. Finally, preventive measures includes, in terms of what we would compensate, any damage caused by measures taken. So if in order to access a certain area, a responder has to take out a few trees, for instance, that may be compensable, or if there's any property damage in the course of a response. Oil pollution damage, what does this include exactly? Well, it includes property damage. Okay, well, what exactly do you do if you have property that's been contaminated by oil? Well, you might be able to clean it, in which case we would cover the cost of cleaning. You may be able to repair it, or you may have to repair it. Or, you know, if it's absolutely destroyed, you may need to replace it. Also, we would cover economic loss. This means loss of earnings. Now, on a micro scale, we're talking about loss of wages. People who may be employed, for example, in the tourism industry or in the fishing industry may have to forgo some income in the wake of an oil spill. On a larger scale, we may be looking at corporate profits, and those too would be compensable. Even if the claimant's property is not damaged, it's possible for people to seek economic loss compensation from the Ship Source Oil Pollution Fund. What do I mean by this? Well, let's take, for example, a fisherman who usually fishes in a particular area. Well, if that area is contaminated, well, it's not possible to fish there. It may be possible to fish somewhere else, in which case we would compensate the additional cost of getting to those alternate fishing areas. Economic loss in terms of no property damage might also be seen in the tourism industry or other industries. Environmental reinstatement. So this goes a little bit to the question we received earlier. What does this mean exactly? Well, it's a little bit different from property damage because generally speaking, the environment wouldn't be considered property. But it's also a little bit different from preventive measures as well, because we're talking about the longer term here. And in fact, future damages or future measures that need to be taken would also be compensable here. So we're looking at any measures taken to accelerate the natural recovery of the environment. And this would include environmental impact assessments, which I believe probably lines up with the question we had earlier on resource impact studies. Okay. Claim compilation costs. Oh, we've got a question here. I'm sorry. Do you pay for measures that don't work, so long as those measures were reasonable or justifiable, which is to say they had a reasonable chance of succeeding? It's a very good question. Effectively, yes. More detail to come very soon. We do look at reasonableness just as the IOPC does. Thank you so much for that. What else might be compensable? Well, professional advice and assistance might be sought by claimants in compiling and submitting a claim to the administrator. Why do I say might and may be compensable? Well, if your claim is very, very small, odds are you'll be able to put it together yourself without too much difficulty. In fact, we're launching resources on our website today that help you to do that. But if we're talking about a very substantial claim, a very complex claim, a claim that might raise legal issues that you don't necessarily understand or aren't confident to move on, you may decide to engage a lawyer or another advisor. To the extent that those costs are reasonable, the administrator may compensate them. We'll talk a little bit more again about reasonableness in a moment. Okay. Now, here's a final important detail on this front. When do you submit your claim? The short answer, as soon as possible. We're talking here about what's called a legal time bar, and this is very important because if you miss the time bar, you're no longer able to submit a claim to the administrator directly. So again, submit your claim to the administrator as soon as possible. Was there an oil spill? If there was an oil spill, you have 2 years effectively from the date of the oil spill. If you want to be cautious, get it in well before that 2-year line. Was there no spill? Are we talking about preventive measures here, or perhaps damage that was caused by preventive measures? Well, you may have up to 5 years, but I put an asterisk here for a very important reason. The no spill situation gets quite complex. Let's say you have a vessel that runs aground and doesn't spill immediately, but a year later it spills and there's damage as a result. Well, effectively 3 years from the grounding is your time bar. So it's that 5-year absolute deadline that runs from the date of the incident, and as soon as there is a spill, a 2-year deadline will engage. So it's possible, for instance, for a claimant to file a claim 5 years after an incident if there is no oil spill. But again, we stress, be sure to file your claim as soon as possible because the time bars can be quite complex. And I should say as well that if by some unfortunate circumstance you miss the time bar, you have an additional year to file a court action against the owner of the ship. And what does this mean? Quick recap, it means that the administrator does become involved and liable to compensate over and above whatever the ship owner can't for whatever reason. But again, you're going to incur a degree of complexity and legal fees if you are forced to go to court. So if you want to take advantage of the first recourse option, go directly to the administrator well within 2 years of the incident. Assessment overview. What exactly does our assessment look like on this end? I say our assessment, but in fact, the administrator is the ultimate decision maker. She may seek advice, whether from lawyers such as myself, or expert marine consultants, who we keep a few of those on staff, and they're fantastic at what they do. But ultimately, the decision lies with the administrator. She takes advice from her advisors, and she issues a decision to a claimant. Our core assessment principles. Let's touch on this in some detail. Number 1, no double recovery. This is quite a common legal principle. Essentially what it means is that if you've already recovered as against the owner of a ship, you are not able to recover against the ship source oil pollution fund. That would include the owner's insurer. It would also include other government, whether they're provincial government or otherwise, fund type compensation schemes similar to ours. So that's something that we occasionally look for, but it's not common that we see issues with that. Number 2, Claimants must provide evidence of their damages, of course. Well, we'll talk about evidence in some more detail later. Damages must be caused by oil carried on board a ship. We've talked about this already, but the word I want you to focus on here is caused, okay? There needs to be a direct connection between the oil spill or the threatened oil spill and the damages that you suffer. So by all means, use evidence to show this connection if it might be unclear. Finally, reasonableness, and this is one of the biggest principles that I want to spend some time on here. What does it mean? In essence, it means proportionality. Now, I should explain what that means as well. Essentially, what it means is if you have a $2,000 problem and you spend $10,000 to fix it, that can't be reasonable. The best you could possibly see from us is about $2,000 on that. What do I mean by this? Effectively, whatever damage you suffer or stand to suffer needs to match the response that you undertake and claim from the administrator. So effectively, if you're claiming for property damage and you've decided to replace damaged property that could have been reasonably cleaned, this replacement cost is probably not going to be compensable. And the same would go for preventive measures. If you're taking measures that are vastly disproportionate to the threat, those measures will not likely be compensable. Now, I want to take a step back from that and emphasize that during a response, not all the facts are known. It could be an emergency situation, it could be pretty high stress. So it's important, effectively, that you document every step of your decision-making process. It's important that we see that you're making the best available decision, or at least a reasonable available decision, based on the facts that you have at the time. So we think about real-time decision-making. We think about adaptability of decision-making. If you see that circumstances have changed, perhaps your response should change to match those circumstances. Finally, minimal duplication of efforts. Let's say you have a number of organizations such as the Coast Guard, a provincial agency, a small government, a local government, I should say, and perhaps private individuals engaged in a response. Well, in that case, there probably will be some sort of broad overarching coordination plan. It's important that your response fits that plan. If it doesn't fit that plan, I don't want to say that your measures won't be compensable, but certainly the level of scrutiny from the administrator will be increased. So, finally, claimants should make efforts to minimize their own damages. Now, I'll go back to that example of a fisherman who is not able to fish in his or her usual fishing grounds. Well, if there are alternative grounds where that fishing enterprise can fish, it's important that we have an explanation why those alternatives were not taken. Effectively, we're only likely to compensate in that situation the cost that the claimant would have incurred to use that alternative. If there is no alternative, tell us about it. Now, also, minimize your damages in the context of property damage as well. If there's oil coming to your property and you take no measures at all or you make no calls, it may affect your ability to collect from the administrator, particularly if there was a good amount of time as between the incident and the time of the damage. Evidence. Let's talk about this in a little bit more detail. First and foremost, a narrative, written, typed, in point form, in paragraph form, it doesn't matter. The key here is to tell us what happened from the beginning to the end, okay? What caused the incident? What did you do in response? Describe the damages you suffered and describe your decision-making process in real time. This might include things like photographs. If you include photographs in your claim, absolutely time or date stamp them. It's very important for us to be able to place them into the perfect context. Next, correspondence. If you're writing to the Canadian Coast Guard, if you're writing to a port or a marina, if you're writing to the vessel owner, it's very important that we have this to give us more context on your response. Contemporaneous notes. What does this mean? Well, during your response or during the time that you suffer damages during an incident, you may be taking notes. It's important for us to have those. Why? Well, we've talked about how important it is to know what you were thinking in real time. Well, this goes to that. And finally, you need to prove the costs or the damages that you've incurred. So if you pay invoices, an invoice, for example, is not necessarily an indication that you have paid anything or incurred a cost. It's an indication that you've been billed. Ideally, you want to provide some proof of payment, which might be a receipt, it might be a paid stamp. We also want to know when you incurred a cost. Why is this important? Well, we pay out interest to claimants. From the time that they suffer a damage, from the time that you as a claimant suffer a damage, you are entitled to interest from the Ship Source Oil Pollution Fund. So effectively, we bear the costs of the assessment. We bear the cost of the waiting period between the damage and the compensation. And finally, I want to note it's very important that you keep all the documentation that arises from an incident so that you can submit it to the administrator. How does the claims process work? Okay. Here's a little map of what it looks like when you submit a claim. Now, we've covered most of this. We've got oil pollution damage, we've got how to submit a claim. I'll note that there's a fast track process available for claims of $35,000 or less, a little bit more on that later. The assessment, what do we look for? Okay, we've talked about that already as well. Now, offer and compensation. Once the administrator has completed her assessment based on the evidence that you provide, and occasionally the administrator will reach out during the assessment process to obtain further information or clarification, always in your interest to cooperate during that process, I should add. The administrator will issue a letter of offer, or in very limited cases, a letter of dismissal or disallowance. At any rate, it will set out all the reasons for her decision, and effectively you've got 60 days to accept it. And you've got to make sure you accept it within those 60 days because it will disappear thereafter, or you can appeal it to the federal court if you're not satisfied with the result. Finally, recovery. We've hinted at this several times. The administrator has a two-part mandate. First, she compensates victims of oil pollution. Second, she goes after the owners of the polluting vessels. To the extent that it is reasonable to recover against them, she will expend resources to go after them. Now, this may mean in the federal court, it may mean in provincial courts, superior courts in the provinces. And one thing to note here is that your participation at this stage as a claimant may be needed. So your relationship with the fund does not necessarily end when you receive payment. You may be obligated to make a statement, whether a written statement such as an affidavit or testimony in court should the matter go to trial. And I'll say that that's actually very rare. Two options. I believe we have a question. Okay, do you try to recoup? Yes, absolutely. Do we try to recoup costs from the polluter to the extent that it is reasonable to do so? We absolutely make every effort to recover against the polluter. As a lawyer here at the fund, my role is also twofold, just like the administrators. I'm very much involved during the assessment process, but also involved during the recovery process. Now, your first option is our general claims process, and that's what most of this presentation has been directed toward. Your second option, as of December 2018, is this expedited process for small claims. What exactly is a small claim? It's a claim that is $35,000 or under. Now, I want to stress before we get started that the optional process, it's an optional process. Effectively, you can submit a claim of $200, as we've learned, under the general process, but you've also got this option to go through with the expedited process. All right. I should note from the outset as well that the small claims process excludes claims for economic loss where no property damage has been suffered. So remember that example of a hotel that has to close because there's a response going on. Well, the damages on the economic side suffered by that hotel, assuming there's no property damages, couldn't be claimed under the small claims process. You'd have to go through the general process. So first off, your claim is going to be simplified. This expedites things for you and for us at the outset anyway. Submit your claim within 1 year of the incident. So you'll notice the much tightened timeline here if your damages do not exceed $35,000. Now, what you submit to the administrator will effectively be limited to a few items only. Obviously, your personal information, along with banking information, so we can quickly transfer the funds that you may be eligible for. What else? A description of the incident, but keep it simple. Keep it to bullet form, and you don't necessarily need to provide any detailed evidence at this stage, but you will later. What else? A description of the damages that you're claiming for, including the total amount of your claim. This is important for obvious reasons, but you do not need to back it up with evidence in the claim at this stage. Finally, an attestation, attesting to the fact with a signature that you believe the claim to be true, you believe the damages you suffered to be a result of ship source oil pollution or the threat thereof. And finally, you need to effectively promise that you will provide the administrator with backup documentation in full within 30 days of receiving a request. If you do all these things, and if you do all these things within the regime, you'll be entitled to payment within 60 days of your submission. The administrator pursues recovery under subrogation as she ordinarily would. What does this mean exactly, subrogation? This is taking on the legal rights of the claimant against the polluter. Now, as I mentioned, the administrator has the right to reassess your claim in more detail. This is where you will receive a written request for more evidence. You provide that evidence, the administrator goes through her usual assessment process in which she may reach out to you for more information. And ultimately, she makes a decision. Now, she may decide that everything has been established on the evidence and effectively the assessment of the claim is complete, or she may decide that there have been some amounts that represent overpayments, things that the Ship Source Oil Pollution Fund is not rightfully responsible for. Now, the reassessment process is very important for two reasons. First, it ensures the proper functioning of the SOPF, and second, it makes sure that the administrator has the evidence she needs to pursue the polluter. Very important for both sides. Now, we talked a little bit as well about our new resources. These have been launched as of, in fact, late yesterday, but today they're very much live on our website. The General Claims Manual, you have these attached to our presentation. The expedited process for small claims, guidelines, and form. Now, there's a form actually attached to that document that you can fill out in order to submit a claim to the administrator. And coming soon, we have two further documents. We've got more in-depth guidelines on how to prepare a claim, and this is applicable to both regimes, the small and the general claims, as well as a special manual for certain kinds of hunting, fishing, and aquaculture losses in the context of economic loss. Now, what are the next steps? We absolutely invite you to share everything that is available today and on our website. We invite you to share the link to this webinar, which will be posted to our website. And we have a survey for you, which we will circulate tomorrow, I'm told, via email. So by all means, fill out that survey. We're very curious for your feedback, and we're happy to take any questions, whether today, we've got a few minutes left, but the first thing I want to do is proceed with a poll. I think it's been pushed to you now, so we'll go back to that last slide. Perfect. So the question is, would you be interested to attend a webinar on compensation and liability for the fisheries sector? So a very targeted presentation there. Great. Seems we're seeing a lot of interest. Good stuff. Wonderful. Questions. So if you have questions now, we have 5 minutes left. We're happy to take them. And okay. Interested in learning more about the SOPF and our last 30 years? Okay, you can join our distribution list at that link. And feel free to contact us at that email. Or, of course, you can call our office, or you may be lucky enough to know one of us, you can reach out directly. So, we have a few questions remaining here. Can you put this PowerPoint presentation on your website? The PowerPoint presentation is available as part of the webinar. We may consider putting it up independently, but we see them as very much tied to one another. So the whole thing will be accessible as one document for now. We got another question. When can the small claim be used? Interesting question. I assume this is based on the timeline, of course, 1 year after the incident. And in fact, I recognize the name of the person who's asking this. So in the context of Coast Guard, basically for any kind of response that Coast Guard undertakes, you've got a year to submit a small claim. Do we have any other questions? Yeah. But of course, it has to be $35,000 or less in damages, and that doesn't include interest. Does the property have to be directly touched by oil? Okay, example, a beachfront hotel versus a hotel in the same town in order to have their economic damages compensated. So in the case of a hotel that does not suffer any physical property damage, it is still possible to claim against the SOPF if you have incurred some kind of demonstrable economic loss. If attendance, if business at your hotel is slowed down effectively by the oil spill, that would be compensable. As would, I should touch on this as well, a marketing campaign to drum up business after a demonstrable decline. So a lot of evidence would be required to support this, but yes, this would be compensable. Now that the Nairobi Convention on Wreck Removal is now in force in Canada, okay, as of just a few months ago, what order would claimants need to follow? Seek compensation from the insurance held by the ship owner first, then from the SOPF. Now, I want to stress here that there has to be an oil pollution threat in order to access the SOPF. So if the oil pollution threat is very much present, and if you have evidence of that, you can come directly to us. In the context of a more wreck removal related issue, you would be obligated to go against the insurer should you have direct action. Do we have any other questions? Okay, how clean is clean? Here's an interesting question. How clean is clean? Now this is going to call up the idea of reasonableness yet again. In other words, when do you walk away from a response operation, even though not everything has been cleaned up or the environment is completely restored? Now, I want to stress that the SOPF is not here to give you guidance on your response. How clean is clean may differ from person to person. It's very subjective and it's very dependent on the circumstances. But what are we going to compensate? Well, it's all going to depend on the evidence that you're able to provide. So to the extent that what you do looks proportionate to the damage that's actually incurred, we will compensate it. Okay, so we have a ton of questions I'm noticing, and we are running out of time. So what we're going to do is we're going to record all of these questions and we'll post written answers to them on our website by the end of the week, okay? So thank you everyone so much.